Hello and welcome to another episode of Talking Politics on the Hindus YouTube channel. This is a show where we go behind the scenes of stories making the headlines in domestic politics. Now this week we will be looking at the impact, the likely impact, because it is still working out, the likely impact that the Supreme Court's verdict that the state governments have the right to subclassify scheduled castes notified in the presidential list, and a separate opinion by 4 judges that a creamy layer in scheduled caste quotas be considered will have on Indian politics. Now, let's first look at what the Supreme Court has actually said. On Thursday, a 7-judge constitutional bench of the Supreme Court, headed by Chief Justice of India D.Y. Chandrachud, in a majority judgment held that states have a right to subqualify scheduled castes notified in the presidential list in order to provide them more preferential treatment in public employment and education than the other communities included in that category. Now, 4 of the 7 judges on the bench separately said that the government should extend the creamy layer principle to scheduled castes and scheduled tribes, like in the case of other backward classes category. It was necessary, it is said, that to exclude affluent individuals or families from the benefits of reservation and make room for the really underprivileged within these classes. The state, and I quote here, must evolve a policy for identifying the creamy layer even from the scheduled castes and scheduled tribes so as to exclude them from the benefits of affirmative action. In my view, only this and this alone can achieve the real equality as enshrined under the Constitution. Can a child of an IAS, IPS or civil service officer be equated with the child of a disadvantaged member belonging to scheduled castes studying in a Gram Panchayat, Zilla Panchayat school in a village? These are the words of Justice B.R. Gavai in that opinion, and his view on considering a creamy layer within the scheduled caste community, the presidential list of scheduled castes, was backed by 3 other judges, Justices Vikram Nath, Pankaj Mittal and Satish Chandra Sharma, who were on the bench. However, Chief Justice Chandrachud was silent on this creamy layer opinion, but he shared the other bit that the states have the right to subclassify with Justice Manoj Mishra. Justice Gavai opined that unequals have to be treated unequally to bring real equality. It is the duty of the state, he said, to give preferential treatment to backward classes who are not adequately represented. The only dissenting member in the 7-judge bench on subclassification was Justice Bela Trivedi, and saying that the states did not have the power to tinker with the presidential list of scheduled castes and scheduled tribes. The Constitution bench basically followed a reference made by the 7-judge bench in 2020 to examine the constitutionality of Tamil Nadu Arunathiyar's Reservation Act of 2009 and the Punjab Scheduled Castes and Backward Classes Reservation in Services Act of 2006. The latter gave preferential quotas to Balmikis and Mazhabi Sikhs. The Chief Justice of India, D.Y. Chandrachud, agreed that scheduled castes were not an indivisible monolith, that scheduled castes notified by the President under Article 341(1) of the Constitution was composed of heterogeneous groups of castes, races or tribes with various degrees of backwardness. Their inclusion in the President's list by the Parliament under Article 341(2) did not mean that they were a uniform and internally homogeneous unit incapable of further subclassification. The court agreed that apprehensions of potential political tinkering by parties in power in states to expand vote banks cannot obviate the constitutional need for acknowledging and remedying interstate inequality among scheduled castes. Now, in all of this, they also said that states have to produce empirical data to support their claim that a subclass required more beneficial treatment. Again, a state was not entitled to reserve 100% of the seats available for scheduled castes in favor of a group to the exclusion of all other castes in the president's list. The majority judgment basically on Thursday overruled a 2005 verdict in the E.V. Chinnaya case, which had held that subclassification amounted to tinkering with the presidential list by the state legislature and was therefore violative of Article 341(2), which exclusively vests with Parliament. Now, all of this is the judgment. Judgment is pretty clear. 7 judges, out of which 6 were in favor, 1 was not. Said that subcategorization has to happen. Out of these 7 again, or out of the 6 who agreed, 4 said there has to be a creamy layer. The other 2 were silent. So there seems to be a definite direction, a definite poke to the government in this verdict. But what will be the political impact of this verdict? Well, political reactions were slow to erupt at the time of recording this video. The Prakash Ambedkar-led Vanchit Bahujan Aghadi in Maharashtra had decried the verdict, while chief ministers of Congress-ruled Karnataka and Telangana and TDP-led Andhra Pradesh welcomed it. Nationally, neither the Congress nor the BJP had put forward a considered reaction. Again, this is Friday afternoon that I'm recording this video, so please give me that benefit of doubt. Later in the week, if they do come out with a considered reaction, please don't hold me accountable for that. While salami slicing off backward communities from a monolith has been seen as one way of breaking the monopoly over the political support of these communities from an umbrella alliance to aggregating these individual communities, the verdict of the Supreme Court on scheduled castes does not translate easily into black and white. Now, why do I say that? Now, while in Uttar Pradesh and other states, the BJP has paired the non-Yadav OBCs from the Yadav community to weaken the Samajwadi Party's support base in the past of an umbrella sort of OBC plus Muslim combination. The only instance where the BJP has advocated the subcategorization of an SC community within the category is the Madiga community in Telangana. In 2023, before the assembly polls in Telangana, Prime Minister Narendra Modi had announced that he supported the subcategorization demand of the Madiga community and later announced the setting up of a central committee to go into the issue that is still happening, that is still kind of, playing out. Now, while the Apex Court's verdict, with the Apex Court's verdict, the power that used to vest with the central government, the center has to decide whether a particular subcategorization can take place within the scheduled caste category, which is there in the president's list. The SC verdict very clearly says state governments now can go ahead and do this subcategorization. And political parties will, it is likely, move forward on their electoral planks. For example, Karnataka Chief Minister Siddaramaiah has already announced that his government will do its best to consider the recommendations of the Justice Sadashiva Commission that had been set up in 2005 to look at internal reservations. In fact, it found a place in the Congress's manifesto in the state assembly elections. And basically, this commission had said that there is big scope for quota within quota in the SC category of castes, SC castes in Karnataka. What is more problematic for political parties is the creamy layer concept. See, subcategorization, you can still think about, okay, let me consider, say, the Madiga community and let me kind of go ahead. Because my government has given this subcategorization, at least I get their support. The rest are not supporting me, or they still will support me, or whatever. You can kind of play around with that. But what is problematic for the political parties largely, and in terms of ideologically as well, is the creamy layer concept. It was till now only applicable in the OBC category and the subject of much opposition even there. Now, OBC communities have been socially and educationally backward, but many of them are also, say, dominant communities. Some have land holdings, etc., which is not the same level of deprivation that scheduled caste communities have traditionally faced. So if you apply the creamy layer thing to scheduled caste categories, you'll have to kind of, this is a bit of a leap for political parties to make. Reservations, opponents of the creamy layer concept say aims to address social and educational backwardness and not economic. But the SC verdict, as I said before, has now created a politically problematic situation for political parties, since the ball is now in the government's court to take this further. The Supreme Court's verdict will have a big impact on politics, quite like the way the Mandal Commission report did, or BJP's Mandal 2.0 of non-Yadav politics being separated from the larger OBC umbrella. It is, however, an administratively tricky issue to pull off and will require much political authority and dexterity. Something which every political party which is at the head of the government will have to think about. Do they want to expend their political authority on a subject where nobody wins? We will revisit this topic once the needle on this moves again. For this week, however, this is all I have. Thank you so much for watching. I shall see you next week.